Welcome once again to Know Your Rights University in association with Natural Essence LLC. We are back at you live, coming at you once again with another video that we hope will be educational and beneficial to you all. Let us begin by sharing our screen. Today's video is going to be called Property in Trust is Protected Against Predators and also against errant children. Is it true that a properly structured, irrevocable trust may protect property and assets from your children's creditors, gold digger spouses, or children with drug habits, etc.? Short answer, yes. A properly structured, irrevocable, spendthrift, non-grantor, complex, discretionary trust is one of the strongest asset protection structures recognized under U.S. law. When drafted correctly, it can shield trust assets from your children's creditors, divorcing spouses, predators, poor decision making, addiction issues, and other financial or legal vulnerabilities. Below is the precise legal reasoning. Why these four structural elements create exceptional protection. A trust that is irrevocable, spendthrift, non-grantor, complex, and discretionary enjoys layered legal protections that work together to prevent outsiders, including creditors, from reaching trust assets. Number one, irrevocable trust removes legal ownership from the beneficiary. Once assets are transferred into an irrevocable trust, the beneficiary does not own the assets. Creditors can only reach what the beneficiary owns. Since the beneficiary has no enforceable right to demand distributions, creditors have nothing to attach. Courts cannot force the trustee to distribute assets to pay a beneficiary's debts. 2. Spendthrift clause. Direct statutory protection from creditors. A valid spendthrift provision prevents the beneficiary from assigning their interest and allows the trustee to refuse access to creditors. Spendthrift clauses are enforceable in virtually all jurisdictions and block credit card creditors, lawsuit judgments, tort claimants, business creditors, and bankruptcy trustees. Spendthrift protection applies both before and after distribution unless the trustee voluntarily chooses to distribute. 3. Non-grantor status. Trust is a separate legal entity. A non-grantor trust means the grantor does not retain control or beneficial interest. The trust itself is a separate taxpayer and separate legal owner of assets because the beneficiary did not create or fund the trust. The trust is not viewed as the beneficiary's property. Their personal creditors have no claim to trust principal. This insulates the assets from divorcing spouses, lawsuits, settlements, and judgments. Number 4, discretionary trust. Beneficiary has no enforceable right to payments. If the trustee has full discretion over distributions, the beneficiary cannot force the trustee to pay them. Nor creditors therefore cannot demand or intercept any required payment. Courts across the U.S. consistently hold if the beneficiary cannot compel a distribution, neither can the beneficiary's creditor. This is the most powerful asset protection feature. 2. Who this structure protects against: children's creditors. Creditors cannot penetrate the trust or force distributions. Divorcing spouses, gold digger spouses. In most states, discretionary trust assets are not marital property, are not subject to division and divorce, cannot be counted as part of the child's personal estate. Children with addiction or spending problems. The trustee controls all distributions, preventing misuse of funds. Children with lawsuits or judgments against them. The trust is not reachable for settlement, lien, or collection. Business failures, bankruptcy, tax issues. Spendthrift and discretionary status typically protects assets even in bankruptcy. 3. Limitations and realistic boundaries. Although extremely strong, the trust must be properly drafted, properly funded, administered by an independent trustee, not used to defraud existing creditors. Fraudulent conveyances rules apply everywhere. Also, most states recognize exceptions for child support, alimony, and certain federal tax claims. Also, certain exception creditors varies by state. Even then, the creditor usually receives only distributions actually made, not trust principal. 4. The bottom line. Yes, when properly structured and irrevocable, spendthrift, non-grantor complex discretionary trust is one of the most robust legal tools available for multi-generational wealth preservation. Asset protection. Protection from beneficiaries' personal vulnerabilities. Divorce-proofing assets. Lawsuit immunity. Protection from bankruptcy and financial mismanagement. It is the same structure used by high net worth families, legacy estates, and institutional wealth planners. What about revocable trust? What about a revocable trust? Does it provide the same protection? Why revocable trusts do not provide asset protection? A revocable trust, sometimes called a living trust, is not an asset protection vehicle under U.S. law. This is true in all states and under federal legal principles. The reason is simple. If the grantor can revoke the trust, amend it, or access the assets, then the grantor is still the true owner of those assets. Below is the detailed explanation. 1. The grantor retains complete control over a revocable trust. Under a revocable trust, the grantor can amend, revoke, or terminate the trust at any time. The grantor can withdraw all assets without restriction. The grantor functions as both trust creator and often the initial trustee. Because of this, courts and creditors treat the assets as if they are still owned by the grantor personally. Legal principle. A trust that the grantor can revoke is legally indistinguishable from the grantor's own property. Therefore, revocable trust offers zero asset protection during the grantor's lifetime. 2. Creditors can reach revocable trust assets just as easily as personal assets. In nearly every jurisdiction, if a creditor can reach the grantor's personal assets, they can reach the assets of the revocable trust. This includes judgment creditors, tort claimants, contract creditors, business creditors, bankruptcy trustees, and divorce orders, though it varies by state. Courts simply order the grantor to revoke the trust and pay the creditor. Why? Because the grantor retains ownership and can reach the assets. Creditors may do the same. 3. Revocable trusts provide no protection from long-term care claims or Medicaid spend down. Medicaid law treats revocable trust assets as available resources, countable assets, and fully reachable for care cost recovery. For the same reason, the grantor still controls them. 4. The state tax law confirms the grantor still owns the assets. Because a revocable trust is fully within the grantor's control, all trust assets are included in the grantor's taxable estate under IRC sections 2036 through 2038. The IRS treats a revocable trust as a grantor trust for income tax purposes. This underscores that the law does not consider revocable trust assets to be transferred out of the grantor's estate or control in any meaningful way. 5. Spendthrift provisions do not work in revocable trusts. A spendthrift clause is legally meaningless for the grantor's own creditors if the trust is revocable, the grantor is a beneficiary, or the grantor retains control over distributions. Reason: a person cannot protect their own assets from their own creditors by putting them in a revocable trust. Courts describe this as self-settled trust doctrine. 6. Revocable trusts only avoid probate, not creditors. Revocable trusts are popular because they avoid probate, allow continuity of management, maintain privacy, simplify administration. But avoiding probate is not asset protection. Probate avoidance does not equal creditor protection. Anyone suing or collecting against the grantor during life faces no legal barrier to reaching revocable trust property. 7. When do revocable trusts convert to asset protection? Only after the grantor's death does a revocable trust become irrevocable, governed by spendthrift protection if written correctly, and shielded from beneficiaries' creditors. But during the grantor's lifetime, it offers zero protection. 8. Summary: why revocable trusts offer no asset protection. Feature: revocable trust versus irrevocable trust. Can a grantor revoke or amend a revocable trust? Yes. What about an irrevocable trust? No. Can grantor access assets in a revocable trust? Yes. But in an irrevocable trust, no. Available to creditors in a revocable trust? Yes, fully. In an irrevocable trust, generally no. Asset removed from estate in a revocable trust? No. But in an irrevocable trust, often yes. Provide spendthrift protection in a revocable trust? Not for the grantor. In an irrevocable trust, yes, for beneficiaries. Provides long-term care protection in a revocable trust? No. But in an irrevocable trust, possibly. It depends on structure. Provides lawsuit protection? Not in a revocable trust, but in an irrevocable trust, yes, if properly drafted. The bottom line: only an irrevocable trust can provide true asset protection. This concludes our video for today. We hope that it has been beneficial and educational to you all. We thank you once again for tuning in. For more information on trust and estate planning for the protection of your property and assets, feel free to contact us at 708-539-9201 or email us at info@naturalessencellc.com. Thank you, peace, and blessings to you all.